The United Nations Convention on the Law of the Sea is administered by the United Nations Division of Ocean Affairs and the Law of the Sea. This presentation is produced by the Environmental Conservation Organization, a 501c4 not-for-profit corporation. The United Nations Convention on the Law of the Sea, which we will refer to as the Law of the Sea Treaty, or LOST, grew out of a 1973 UN Conference on the Law of the Sea. This conference continued for 9 years before it finally adopted the Law of the Sea Treaty. So onerous was this treaty in the original form in 1982, then President Ronald Reagan refused to even sign it. Realizing that the treaty was meaningless without U.S. participation, and with the cooperation from the Clinton administration, treaty proponents agreed to scrap many of the provisions in Part 11 and renegotiated an extensive 9-part agreement in an effort to cure enough of the flaws to secure Senate ratification. The Clinton administration advanced the treaty to the Senate in 1994, where it languished until 2000, and then it was returned to the President without a vote. The Bush administration asked the Senate again in 2004 to ratify the Law of the Sea Treaty. Nothing about the treaty had changed since the last time it was rejected. State Department legal advisor William H. Taft IV provided the primary testimony in support of the treaty. Opponents were not invited to present testimony. No one even mentioned the most glaring flaw in the entire treaty. Article 2, paragraph 3 says, "Sovereignty over the territorial sea is exercised subject to this convention and to other rules of international law." The clear language of the treaty requires that we subject our national sovereignty over territorial seas to this treaty and other rules of international law. Still, proponents claim the treaty does not infringe upon our national sovereignty. Senator Richard Lugar, who chaired the Foreign Relations Committee the last time the treaty was rejected, says, "Ideological posturing and flat-out misrepresentations by a handful of amateur admirals have sought to cast a shadow over the treaty by suggesting that we're turning over our sovereignty to the United Nations. Their criticisms don't hold water. In reality, it's Mr. Lugar's criticism of his opponents that doesn't hold water, because his words are in direct conflict with the clear language of Article 2, paragraph 3 of the treaty. Sovereignty over territorial sea is exercised subject to this convention and to other rules of international law." Proponents of the treaty contend that the treaty allocates rights that provide for 1. A 12-mile territorial sea, and 2. A 200-mile exclusive economic zone, and 3. A 200-mile continental shelf. But all of these rights already exist. These rights were established by presidential proclamation. President Reagan's Proclamation 5928 formally created the 12-mile territorial sea December 27, 1988. President Reagan's Proclamation 5030 formally created the 200-mile exclusive economic zone March 10, 1983. And President Harry Truman's Proclamation 2667 formally established U.S. jurisdiction over the continental shelf September 28, 1945. This treaty creates an international seabed authority, which has the power to tax through application fees and royalties. It may require technology details from applicants, which it may then share with applicants from other nations. The treaty creates a business called the enterprise, Subsidized by assessments from member nations, the enterprise competes with nations and businesses that wish to mine the seabed.